we understand that certain comments have been made in Parliament, not quite factually correct, about the Secretariat to the Electoral Commission. In 2006, Supervisor of Elections, Mr. Karavaki, was allowed to act as the Secretariat. That wasn't highlighted when the Honourable Member Viman spoke about the amendment. Any comments on that?
Yeah, I mean, essentially, as you know, that we brought about a number of amendments to the Electoral Act was tabled in Parliament last week, and these included many of them. In fact, majority of it, if not all of it, was to do with functional and operational matters of the Elections Office, and to ensure that there is proper and stated guidelines in respect and also legal provisions in respect of what the supervisor of election needs to do. There was also clarity provided where there was ambiguity in respect of, for example, things like timing, etc. But there's also the issue of, as you know, we discussed and Parliament did approve the need to change the numbers. As you know, candidates received different numbers, all had different numbers that had been drawn through a ballot process. And to ensure that there is no confusion in the next elections, the numbers or the set of numbers that were present in the previous elections cannot be present in the next elections. So you need another set of ballot numbers, or candidate numbers, sorry. In the course of that, we also brought an amendment to give it a legal effect, was that the supervisor of elections, the Fijian Elections Office, through the supervisor of elections, will be the secretariat to the Electoral Commission. The two, particularly two members of Parliament spoke about it. That was Honourable Prasad and Honourable Karavaki, who talked about that, essentially intimating that if the supervisor of elections were to become the secretariat through the Fijian Elections Office, then the independence of the Electoral Commission would be questionable, etc. But the fact of the matter is, as pointed out in the amendment, that there is no such issue, and should there be a matter that the Electoral Commission wishes to discuss that could involve the supervisor of elections, then the supervisor of elections would not be present at the meeting, as is standard in all other, for example, board situations where you have board members and you have somebody being the secretariat. If the matter is about the secretariat, then the secretariat actually is not present for that meeting. Unfortunately, in the course of the debate, both these honourable members who spoke about as to why the supervisor of elections should not be the secretary to the Electoral Commission, failed to either mention, or perhaps through ignorance, or perhaps they forgot, that the Electoral Commission in 2006, for the 2006 elections, had as its secretariat the Office of the Supervisor of Elections also. And that is in writing in the EU report. The EU Observer report that's based on the 2006 elections, and the final report says, and I quote, "During the election period, the Electoral Commission met regularly with the Office of the Supervisor of Elections acting as its secretariat." So it would appear that they seem to be okay with the Office of the Supervisor of Elections being the secretariat in 2006, but suddenly they're not okay with the Office of the Supervisor of Elections, or the Fijian Elections Office, being the secretariat of the Electoral Commission now. That is the anomaly, and unfortunately we find that this is the type of misinformation and perhaps missing out of information that is presented or not presented in Parliament whenever we have this debate. So I think the documents actually speak for themselves. You find that in the Hansard, you'll find that both Honourable Prasad and Honourable Karavaki talk about the Office of the Supervisor of Elections and how it would be problematic for the Fijian Elections Office being the Secretariat through the Supervisor of Elections to the Electoral Commission. So that essentially is an anomaly that obviously seems to have been lost on these two honourable members.
Have you let Dr. Biman Prasad and Karavaki know about the EU report back in 2006?
In 2006?
Have you told them about what the report was?
Well, no. In fact, we ran out of time on the day. I did highlight a couple of issues from the Electoral Commission. I talked about how when we discussed, one of the amendments we brought about also in the amendment that was brought about in Parliament last week was that the Electoral Commission must make its minutes of its meetings, must make it available to the public. From memory, it's within 5 days of the meetings being held. And in fact, in that context, I had raised the issue about how the EU had highlighted that this was not the case previously. Let me, if I can quote, "The decisions and the minutes of the Commission's meetings were not published or communicated to the public." This is the EU saying this in 2006. "In some cases, Commission decisions were not implemented by the Office of the Supervisor of Elections, but the Commission failed to follow up on such operational failures." So obviously there was a huge disconnect. "For example, at one Commission meeting, a decision was taken to approve a request by Reverend Aquila Mbaki from the Citizens Constitutional Forum to collect all names of persons who wanted to vote but were not on the register of voters. This decision was not communicated to Reverend Mbaki's group, nor was it implemented. Upon a request by the European Observer Group to observe the Electoral Commission meetings, the mission, which is the EU mission, was invited on only one occasion, on 27th April 2006. So I had actually read out that part in Parliament in reference to the in reference to the EU report. But regarding that specifically, I ran out of time to be able to read that. I did not actually have the hard copy. I had the soft copy. Those of you who were in Parliament would have seen that we actually were reading from the phone. But of course, I mean, the reality is that Honorable Karawaki was actually Supervisor of Elections. This could have been pointed out in the debate in Parliament last week, that the Office of the Supervisor of Elections did actually act as a Secretariat. Perhaps he forgot. But the fact of the matter is that that does not take away from the fact. And the fact is that, as stated in the EU report, the Office of the Supervisor of Elections was the Secretariat to the Electoral Commission. And in this particular case, we are now giving it legal provision. And that is to say that they will be the Secretariat to give support to the Electoral Commission.
Minister, could you elaborate on how, if in this situation there is a conflict of opinions on the powers of the supervisor and the powers of the commission, or if there's a difference within the commission while the supervisor is acting as secretary, how would they go about negotiating this, given now that the supervisor is also secretary to the commission?
Well, the fact of the matter is the Constitution is quite clear as to what the role of the Electoral Commission is, and indeed what is the role of the Supervisor of Elections. The Supervisor of Elections essentially, or the Fijian Elections Office, I should say, Fijian Elections Office actually implements those operational aspects that's required of the Electoral Commission. Now, invariably, the fact of the matter is that there should not be much anomaly or much ambiguity in respect to that. However, as the law provides, should there be an issue that they want to discuss about the Fijian Elections Office, then the Electoral Commission can ask the Supervisor of Elections to excuse him or herself, whoever it's going to be, the Supervisor of Elections. That's the safeguard that you have. In the same way, for example, at the moment in many of the boards, you have the CEO of the company actually performing the role of the Secretariat, CEO of the staff. Now, should the board want to discuss a particular matter that may relate to the CEO or that may relate to particular staffing issues, then they are asked to be excused. So somebody else is brought essentially to take the minutes, but those people are asked to be, they stand aside for the length of that meeting whenever that subject matter is being discussed. So there's no issues as such. I mean, of course, there are many other issues that emanated from the previous Electoral Commission, and you can see read the Hansard that we had highlighted, and that's for you to read to be able to ascertain what those anomalies were and how they went about their work. But the fact of the matter is that, and the point is, that when these matters are discussed in Parliament, we need to have the facts. We need to be able to have people discuss the issues in an apolitical manner. And if you read the amendments that have been proposed to the Electoral Act, they predominantly do with, operational aspects. If you see, for example, polling booths are now no longer called polling booths, they're called polling screens. So the amendment is about to change the name from polling booth to polling screen. Definition of what is a day. As you know, that there was an issue about what constitutes a day. Is a day, night and day as we know it, is a day, 24 hours a day. So all of those anomalies have been, addressed, or ambiguity, I should say, have been addressed in the electoral amendment that was put before Parliament last week.
The other issue that was brought up in Parliament was with regards to your role as Minister responsible for elections and also being the General Secretary of Fiji First.
Yes.
The point was made that this could constitute to a conflict of interest or possibly you unduly influencing the electoral process. Those insinuations were made in Parliament.
Well, as you would have also heard in Parliament, we said that the last minister who was responsible for elections was Lesenian Garase. And he was the leader of SDL. And he was the minister responsible for elections. Isn't that a bigger conflict? If you want to take it on the face value of what role the person plays within his or her party. The leader is obviously the bead of the party, and he was being the minister responsible. You see, so if you read the Hansard, you see, when we responded, he said the Honourable Attorney General has to understand the minister, as Minister of Elections, he was also the Secretary of Fiji First Party in the last elections. And then we had interjected, and the Hansard report obviously does not capture that properly. Then I said, well, the leader of SDL was also the minister responsible for election in 2006. Then he says, that is fine, but he was the Prime Minister. Exactly, he was the Prime Minister and he was also minister responsible for elections. Isn't there a conflict there? So the point is this. You have to look at what actually happens in practice. The minister responsible for elections essentially looks at the legal aspects of it. We don't tell the Office of the Supervisor of Elections or Fijian Elections Office how to run their operations. We don't tell the Electoral Commission how to run their operations. You can go and ask the Electoral Commission members. Did we at any point in time, the former Electoral Commission members, tell them how to run the office? We did not tell them how to run the office. So you see, this is again just politicking. And the point of the matter is, in the same way, for example, we are the minister responsible, the Minister of Economy is responsible for the Bureau of Statistics, but it's an independent office. It essentially means the budget line comes to the Minister for Economy, the same way the budget line comes for the Auditor General's office, to the Minister of Economy. Are we telling the Auditor General how to audit the books? Do we go and tell them which ministries to audit? Do we tell them how to write the report? No. So by that standard of supposed conflict that Honourable Prasad is using, that means nobody really can become the minister responsible for the Auditor General's office. And you have to look at the extent of the power of that particular ministry. So the independence of these agencies, the Auditor General, the Fijian Elections Office, the Electoral Commission, Supervised Elections, is guaranteed in the Constitution. Anybody breaching that or negating that independence would be in breach of the Constitution, and there would be constitutional redress for that. So it does not hold any logic.
You've made reference to how issues are now being politicized in Parliament. We are drawing closer to the elections in 2018. Everybody expects a lot of political issues to come up, a lot of non-political issues to become politicized. Are you expecting, or are you prepared for issues to sort of take a nasty turn, or for a lot of issues to sort of turn political where it does not need to be? Do you foresee that happening? We saw a lot of it in the previous elections. You as minister and even the supervisor of Fijian elections office at almost every point had to sort of interject and say, look, this is not the case. Issues which need not be political are being used to gain support.
Well, I think, a lot of it depends on the level of integrity of the debate that comes from the other side of Parliament. Obviously, the Fiji First government under the leadership of the Prime Minister have always maintained a particular level of decorum and integrity in respect of discussing these kinds of matters, national matters. And we've always stuck to that. So we do not, politicize matters that do not need politicizing. We do not politicize matters that are of national, importance, of national significance, or has a national application. Of course, political parties will, have politics or have their own political philosophies and can argue about the merits or demerits of those philosophies. But to be able to, or to want to politicize matters that go towards, for example, operational aspects of ensuring that we have, very smoothly run elections. Everybody wants that. Everybody is very critical. You may recall prior to the 2014 elections that elections cannot be held in one day. We'll have huge problems. We won't be able to get the results. I mean, the results actually spoke for itself. The multinational observer group said that the elections were credible, the processes were fair. We had 0.7% of invalid votes, less than 1%, completely unheard of. We had one of the highest number of voter turnouts. Notwithstanding the high voter turnout, we had a 0.4% of votes being invalid only. Take your next, the previous benchmark, 2006, number of invalid votes was 9.4% in 2006. So, you see, I mean, these are the kind of issues. And of course, I mean, if you read this report, and I urge all of you to actually read this report, we had given copies of this out back in 2007 and 2008. Maybe you need to refresh yourselves. I mean, there were huge discrepancies, huge problems with names of people not appearing on the voter list. Complete dozens and dozens of names not appearing, or either completely missed out, or appearing in another constituency. In those days, as you know, we had different constituencies. So we obviously, when we present these amendments to Parliament, we want to ensure we sit down and talk to various advisors. We get the input from the Fijian Elections Office. As we mentioned in Parliament, we have a gentleman called Laurie McGrath, who's from Australia, who's recently been appointed to the Public Service Commission. He has a lot of practical knowledge, and they also provided inputs in respect of how we can improve the processes. So this is all done to ensure that everybody has greater transparency. That on the elections day itself, things are run smoothly. For example, there's now the specific discretion being given to allow the opening up of polling stations, specific to that particular area. So you may, for example, have in a particular, say if you have in an island, people may all vote. It's a very small island with maybe one or two villages. Everybody votes by 12 o'clock. What's the point of keeping it open till 6? Or, if not everybody has voted, there may be an opportunity to have the polling station open till 7. As opposed to on that day, saying, oh, there's still a lot of people out there, let's extend it. In this particular instance, the Electoral Commission now has the powers to predetermine beforehand, to say, look, there's only one village there, or only 50 voters there, there's no point opening it till 6, you can close it midday. And remember, we have a public holiday. Or they may say, look, this polling station is far away from all these isolated homes. People may need to get there, get there later on. They may come by horseback, whatever the case may be. So let's keep it open till about 7 p.m. or 8 p.m. So those are the kind of latitudes that's been given to the Electoral Commission. But the great thing about it is that it's practical. The great thing about it, it's actually envisaging issues from lessons that were learned from the last time. And also, the great thing about it, it gives the Electoral Commission that level of discretion, but it is actually put in law. And you see, one of the problems that was highlighted in 2006 and other elections is that there were too many discretionary powers. that were given to a number of people. So you have, for example, persons in the previous elections, when all the voting, when all the ballot boxes arrive from different polling stations for one constituency, generally they do the reconciliation, and then once they do the reconciliation from the polling station with the number of ballot boxes sent out, ballot boxes that have come in, then they close it. They close their constituency, then they open up all the ballot boxes and count all the votes. In the Lavinia Padarat case, as you may recall, what happened was, when they closed it, I think from memory, 6 ballot boxes arrived later on. And the person who was in charge of it allowed it to come in. Now, the moment you have that, you are actually creating a lack of confidence within the system. That should not happen. You're creating a lack of confidence. So those are the anomalies that obviously did not take place in the last elections in 2014, but we need to make sure that none of that ever happens. So we need to continuously review laws. I mean, if you go to Australia, if you go to various other jurisdictions, they continuously are reviewing the laws to ensure that any practical issues that may arise, that did not arise from the last time, but may arise in the future, could actually be addressed.